am Zoe Frost with Celebration Magazine Live, and today we have with us Brandon McGee from McGee Law Firm. Brandon is an amazing presenter, does a great job every time, and I am excited to see what estate planning and shoes have in common, because I love shoes. I mean, so I'm excited to see where my match is coming. And that might be what it is. It's not one size fits all. So I am going to turn the floor over to Brandon. And don't forget to unmute yourself, darling. And we will get this Zoom and Learn started. Unmute yourself, Brandon.
Can you hear me?
Yep, got you now.
Okay, wonderful. Well, thanks so much. And thank you guys for joining. This will actually be my very first time to present what do estate planning and shoes have in common. So hopefully this will go well, but we hope to make some parallels that kind of help people understand the purposes and potentials of estate planning. And let's see if I can get my clicker going. One second, guys. Let's see, I just have to do it this way. Okay, so we typically when we present live seminars, which we obviously suspended for a while, and now we've gotten back to doing some of them, but we're still doing a lot of webinars, but we pass out packets of information that reflect what I'm talking about here today. They don't follow the slides 100%, but it's information general information about estate planning, which you'll hear today. If any of you guys would like a copy of those materials, just reach out to us in some way, shape, or form that you see here on the screen, and my staff will be happy to get those materials to you. So a little bit about myself. My name's Brandon McGee. I'm the owner of the McGee Firm. I have an office in downtown Fort Worth and an office in Southlake. However, I have clients all over the metro area and even all over Texas as well. I'm also, excuse me, oh my gosh. Wait 1 second, guys. 1 second. See if I can get, hey, Aaron. Sorry, guys, technical difficulties. I'm in good shape now. Okay, so I have been licensed to practice in Texas since 2002. I'm a DFW native, and I've been focusing on estate planning and elder law since about 2013. That has been my exclusive focus. I'm a member of a couple different professional academies. The first one is the American Academy of Estate Planning Attorneys. This is a highly vetted group of attorneys. I guess I'll call it exclusive. It's an exclusive organization, as opposed to an inclusive organization, which you're not supposed to do that these days, I guess, but we are exclusive at the American Academy. But what that means is simply that the attorneys who are members are highly vetted before we're let in. So when you're working with an American Academy attorney or listening to one speak, you can have a lot of confidence that this is what we do for a living, right? I'm not a general practitioner. I don't have 3 or 4 other practice areas and I just throw in estate planning. This is what I do. And the American Academy is a great organization that gives me a lot of connections and idea exchanging possibilities with really first-rate estate planning attorneys across the state of Texas and in the US in general. I'm also a member of NALA, National Academy of Elder Law Attorneys. To be real blunt and honest, all I had to do to join NALA was be an attorney and write a check every year or so. And I just actually wrote that check earlier today for next year. But although there's not a high vetting process for NALA, so there's a lot of members. It still is a great network of elder law attorneys all over DFW, Texas, in the US. And so we've got some great connections there with NALA too. At our firm, the McGee Firm, we're also a member of the Better Business Bureau, where we have an A+ rating. And I want to talk to you briefly about why I am an estate planning attorney, because as you guys probably know, there are so many different things an attorney can do. That, just like a doctor, right? Focus on a different part of the body, a lot of different areas of the law to focus on too. So I want to give you just a little bit of history as to how I became an estate planning and elder law attorney, because I think that is significant. And so when I was applying to law school, when I was in law school, when I got out of law school, I had no notion whatsoever of being an estate planning attorney. In fact, that probably would have sounded very boring to me way back when. And so I became a litigator, a trial attorney. That's what I wanted to do. To me, that sounded fun. It sounded exciting. It sounded like why you go to law school. You go to law school so you can go in the courtroom and deal with battles, right? Legal battles. So that's what I did. And then for about the first 10 years of my attorney life, I was a litigator, a trial attorney. I've argued cases to juries. I've argued cases to many judges, filed briefs with the Texas Supreme Court, numerous appellate courts. And so I did that for a good number of years. Along the way of doing that, I would start to have organically, I started growing a probate and estate planning practice, because I would have clients that would ask me, hey, can you draft this for me? Can you probate this will for me? And over time, I had kind of a small practice, but I was the guy who, could not say, this is just what I do. I was mainly a litigator, a trial attorney, and I did some estate planning and probate on the side. My kids, you'll see a picture here of my family. That's my wife, Rita, my fraternal twin sons, Cole and Hunter. And what happened, the reason I made a change into estate planning was in the year 2012, I had some medical calamities in my family, things that have happened in a lot of families, but they kind of happened back to me that year. And leading up to the year 2012, maybe for a year and a half before that, I started honestly getting kind of burned out on the trial work. I had gotten married, I had the kids. At this point, there were 3 going on 4. And trial work is something that you oftentimes can't escape from it when you go home. Mentally, it just kind of consumes you, and you're thinking about this and this hearing tomorrow, and I need to get this done, and I need to get that done, and running through different legal arguments in your head instead of paying attention to your family. So I honestly, I just got kind of burned out. I started thinking, this is not something, I don't think I can do this for the rest of my life. I don't think I'm the attorney that wants to be the trial attorney, into my 60s, right? But I didn't really see a logical way out of doing that, given that I was raising a family and had financial obligations, obviously. So in the year 2012, my wife, Rita, in May of that year, at the age of 39, was diagnosed with stage 3 breast cancer. And so this was something that was absolutely shocking to us. It was kind of, it's sort of an out-of-body experience when you're sitting in the doctor's office receiving that diagnosis about your spouse. I'm sure for Rita, it was a much worse experience than for me, but for me, it was bad enough. And so that diagnosis happened in May of 2012. Rita almost immediately started chemotherapy. And then my parents lived in Dallas, which is where I grew up. And my parents, sat me down and they said, we know Rita's not going to be able to do a whole lot the next few months. She's going to be tired, probably sleeping a lot. And, you've got your law practice. And by the way, Rita had a law practice too at that time, still does, but real estate practice. But so they said, we're going to give you all the help that you need with the twins. Don't worry about that. Anything you need, we'll come over, we'll help out. So that was comforting until about 35 days after that conversation on July 1st of 2012, when my father passed of a sudden and massive heart attack at the age of 64. Just like Rita's cancer diagnosis, completely unexpected, completely out of the blue, and just a big shocking event. And so I had gone from a pretty normal life to my wife going through chemotherapy with stage 3 cancer, and my father being deceased, and then my mom, kind of being an emotional basket case, right? Because it was such a shocking event. So I started doing a lot of pondering during that year of 2012, the second half of that year. And I came away with the idea that, number one, I really love estate planning. And the reason that I really enjoy it is because it gives me an opportunity to set up families through their legal documents, so that when these bad things happen, when people die, when people lose their mental capacity, when people get very sick, when people need to go to nursing homes, my clients and their families can be set up in the best way possible. Okay. And in litigation, I was already dealing with the train wreck. The train was wrecked. There was no helping the train along the track, right? But in estate planning, I feel like I can, when these calamities happen in people's families, we can kind of keep the train on the track. We can keep the train moving and make the experience, is at least from a legal standpoint and sometimes financially, is least stressful as possible for the family. So I came out of that year deciding, you know what, life can be short. We might as well get up every morning and look forward to what we're going to do. At that time, I was going to work not in a good mood a lot of days, thinking about what I had to do that day. And so I decided I'm going to throw caution to the wind, and I'm going to become an estate planning and elder law attorney. My wife, Rita, supported me on that. Then she started getting better, finished chemotherapy. So in 2013, I made that change in my law practice, and it's one of the best decisions I've ever made. And so what we do here at the McGee firm day in and day out is estate planning and elder law, and we really enjoy it. And best news of all, actually, as of last month, as of October of 2021, Rita was 9 years, no evidence of disease. So that's the best news, is Rita's doing great. Okay, enough about me. Let's talk about estate planning and shoes. How are shoes and estate plans alike? Okay, number one, both protect you from obstacles. Who of us has ever not had our shoes on in the house and smashed one of our toes into the into the table, into the leg of the table, and it screamed and yelled and it hurts really bad, right? So when you have shoes on, you're protected from that. When you have shoes on and you go outside, you're protected from the elements, you're protected from the cold, you're protected from the wet. Your feet are protected from glass, your feet are protected from rocks that may have sharp edges, right? It's the same thing with an estate plan, similar concept. When you have an estate plan, there's a lot of things that you and your family are protected from, that people who don't have an estate plan are not protected from, just like people who have shoes and people who don't. Okay. Also, both must be up to date periodically. So some of us may have some very old shoes in our closet, maybe some that would even embarrass us, but if we do, it's probably because we don't wear them that often, right? We've got some shoes from the mid 1990s that are way out of fashion, but we just don't wear them that often. I moved my house about 9 months ago and was kind of shocked at some of the clothing items and shoes that I still had in my closet that I hadn't worn in 8 or 9 years, right? So, but with shoes, what do you want to do? You want them to stay somewhat fashionable. They're going to get old and worn out, and you want to get new ones when the sole starts wearing out. So with estate planning, it's a similar concept in that you want to stay up to date with the changes in the law, up to date with your family circumstances, and up to date with your financial circumstances. It's very rare that I have people come in with a real old estate plan and it's still something that would apply. I have a lot of people coming in with estate plans from, let's say, the 1990s, and they just haven't done anything in a couple of decades. And it's almost always the information is outdated. It's very rare that it's not, right? Because things change in life and they can change in a hurry. Also, with shoes and estate planning, both must be a good fit. It's not one size fits all, as Zoe was saying earlier. With an estate plan, something I put together that's perfect for one family might not be sufficient at all for another family. So we all have our particular family dynamics. We all have our particular assets that we have, and we all have our particular goals for what's going to happen with those assets when we pass. So it's not one size fits all. It's got to be a good custom fit, let's say. You need to consider the whole wardrobe. Okay. You can have an awesome pair of shoes that by themselves, everybody thinks those are spectacular. But if you wear them with jeans and a t-shirt, it would look ridiculous, right? Or vice versa. If you wear them, maybe some really great casual shoes, but they would look terrible, you know, in a ball gown or a wedding dress, right? So we need to look at the big picture when it comes to your estate plan. We don't want to just look at things in a vacuum. We got to look at the family dynamics, the assets, the goals, and we have to put together the whole big picture so that the shoes look good with the wardrobe. And same concept in estate planning. Now, choosing an estate plan that is right for you is a bit more complicated than choosing a pair of shoes. I will have to issue a caveat. For us men, that's true. For some of you ladies, the shoe department can get pretty complicated. So sometimes it might be as complex for you guys to pick out shoes. But for us men, definitely the estate planning is more complicated than picking out the shoes. Okay, some common problems that we see, and this is where people don't have that protection, right, is no protection from going to probate court. So when I talk, and this is living probate, so the probate courts in Texas, they have two functions. Function number one is to help appoint an administrator or executor to dispose and distribute somebody's estate, their assets, after they pass, if the family has not set up to avoid that, okay? And a lot of families have not. I also take families to the probate courts, and there's a lot of people have not set up to avoid that. The second function of the probate courts in Texas is if somebody loses their mental capacity, an adult loses their mental capacity, it could be Alzheimer's, a stroke, any number of things. And again, they have not set up to avoid probate court. Their family's going to have to go through probate court to ask the judge to appoint what's called a legal guardian. Okay, that would be a decision maker, a conservator over that person to make decisions for them and handle their life business. Both of those, if we do things properly with an estate plan, we can completely avoid the court system. And we'll look at that here in a little bit. Death probate, again, that's when somebody passes away. If the family has not set up the estate for the assets to pass outside of the court system, which there's a couple different ways we can do that, but a lot of people don't. They don't take the time to do it. Then the court will appoint the person to handle that and make sure everything goes the proper way as much as they can. Why do we want to avoid probate court? Why would, to go back to the shoe analogy, why would I run from probate? Why would I want to have a pair of shoes that could help me avoid probate? It can be expensive. And what I can tell you is, for the most part, the vast majority of the time, when I set up an estate plan for a family to avoid probate court, that is almost always less expensive than actually taking a family through court who did not set up to do it. So it's less expensive usually. It's time consuming. It is stressful. When you go through the legal system, you know, you're dealing with a lot of government red tape, jumping through legal hoops. You're dealing with assets being frozen until you get to the end of the process. You can't sell the house. You can't get into the retirement account. When you set up your estate to avoid court, things are immediate, things are cheap, things are private. When you go through the court system, everything's public, including the information about your estate. That all gets filed as public record, and everybody can see your assets and the values and your debts and the amount of the debts. And remember, like estate plans, shoes will protect you from unexpected obstacles in your path. And a good estate plan prepares you for any contingency, right? If you have a really good comprehensive estate plan, we're looking at a lot of different things that could happen, that could come up, and we're planning the things that you decide you want to plan for. We help you plan for those. I mean, I have some people, they come in and they want to plan for everything. I have some people that come in and they say, no, a couple of those items aren't so important in our life. I don't think it impacts us much, but 2 or 3 of these are really big issues for us, right? And so just like you need to pick a pair of shoes for, you know, are you going snow skiing? Are you going, you know, out to work in the mud, or are you going to church? You're going to pick different shoes. Just the same thing with an estate plan. You're going to have a different approach, different documents to handle different matters. Going barefoot. So this is no documents for passing down assets or planning for incapacity. So this is the person who does not have an estate plan, period. They don't have a will, they don't have a trust, they haven't done beneficiary designations, they haven't done powers of attorney. And what I tell people is this: if you want to punish your family from the grave, if your goal is, I want to make my family's life as miserable as possible when I die, don't have an estate plan. You're going to send them through court. You're going to send them through the most expensive court process there is, the most time-consuming court process there is. Also, the administrator is going to be the most heavily micromanaged by the judge, which is a big pain. Every time you want to do something, you're having to call your attorney and pay your attorney to file a motion so you can go get XYZ done. Really undesirable way to handle things. And again, you're really putting your family in a tough position, okay? Another thing is this: when you don't have an estate plan, this can really open things up to family arguments and family disputes. One of the primary goals that I hear stated in my conference room where I'm sitting right now is, Brandon, I just want to make it to where there'd be basically no reason for my kids to argue when I pass away. Or another one here, big one, no reason for my kids to argue with my wife when I die, who is their stepmom, right? So blended families is even, I would say, more of a red flag for the potential for family disputes after somebody dies. And those disputes, whether they're traditional families or blended families, can get really ugly. People can really end up hating each other. And people can spend a lot of money in the court system and cause a lot of havoc for everybody. So the worst thing you can do is to not have a plan. And again, if you're in a blended family, take special note. Things can sometimes get even worse. Another thing about that is if you're in a blended family, if there's no estate plan and your spouse dies and has kids from a previous marriage, you will own your assets with those kids from the previous marriage. They will inherit a part of their parent share. So very important to take care of those details. No plan to protect your family from the mud. This is what I just talked about, okay? We want a good comprehensive planning, decide who's going to be in charge, first choice, second choice, third choice of who's going to be in charge, who's going to get what's going to happen, so that we can avoid our family get down in the mud with each other. Because the last thing we want is our death to trigger a big family feud. I mean, we don't want our children arguing with each other because we died. We don't want our spouse arguing with our children because it's their stepmom or dad and we died. So very important to take care of, okay? Other things, no protection for beneficiaries. So let's talk about this real quick. I just told you the worst thing that you can do is to not have an estate plan, okay? There's 3 other things you can do that are better than that. And I'll walk you through those from number 2 to number 4. The next best thing you can do after not having an estate plan is to have a last will and testament, okay? And a last will and testament is going to be a document. A lot of you have it or have had one probably, or know what it is. And it names an executor to be in charge of your estate when you pass away. And it says who gets what, who gets this, who gets that, or I have 3 kids, just split everything equal, whatever the case may be. Now, a last will and testament does go through the court system. There's a misconception sometimes that it doesn't, but it does. But it goes through the court system in a much quicker and less expensive manner than not having one. So my clients who have a will that's in good shape, that meets all the criteria of a will for the state of Texas, they'll usually spend half as much time going through the court system, half as much money, and probably 80% less stress than the people who don't have a will. So I want everybody to have a will, no matter what your plan is. I consider a last will and testament to be a fundamental building block, a foundational level of an estate plan. So I want all of you guys to have a last will and testament, period. Okay. What's the next best thing that we can do after that? So we have a will in place, which is good. If we have to go to court, we can do it without having to, spend all the time and money of not having a will. The next best thing is beneficiary designations. And that's where we can designate upon our death. So upon our death, our assets directly through a bank, through a financial company. So whether it's Charles Schwab, Edward Jones, Fidelity, Vanguard, Bank of America, Frost, Chase, doesn't matter. All of these financial companies in the US you can do a death beneficiary. You just have to go tell them you want to do it, and they'll let you do it. What that allows is that when you pass away, your family can go immediately, once they get your death certificate, and start collecting on those funds directly from the bank or the financial company without having to go hire the attorney, interview attorneys, hire one, wait for several months for the estate planning or for the probate process to go through. Then you can go get the assets. This allows for much quicker and cheaper access to the financial accounts. Okay. For real estate, there's something called a transfer on death deed that we can use. It's been in Texas for 6 years now to pass down real estate without going through court. And then for our automobiles, the DMV, the Department of Motor Vehicle, has in-house forms. We have a big stack of those at our office. We give them to all of our clients who work with us, but you can also get it from the DMV directly. Now, what's the next best thing I can do? And I guess I should say, what's the best thing I can do? For most people, it's a living revocable trust. Okay. This is the most powerful and advanced estate planning document we have in Texas and in the US. What are the things that it can do? It can help us avoid probate court. All of our assets that are in trust will avoid probate court. That's great, Brandon, but you just told me I can do that with beneficiary designations. And the answer is yes, you can also do that if you do beneficiary designations. So then why would I want to trust if I can just already do that with beneficiary designations? Other things a trust can do, it can help us avoid the estate tax if it applies to our family at the time that we pass. This is a big one. We can treat beneficiaries very differently. When you pass your estate down through any other mechanism, it can be the beneficiary designations, going to court, whatever the case may be. Once that person is entitled to get their assets, their inheritance, they get it all, period. If it's somebody has a bad drug problem and they have $500,000 coming to them, they'll just get it all at once. If somebody's in a terrible marriage, a rocky marriage, and we're worried about them getting the money and maybe it being subject to division and a divorce, that they'll get it all at once. If somebody's just very young or just financially not disciplined, financially immature, no matter what age, then they will still get their money all at once. A trust is the one document we have that can distribute money out into time. Okay. So, I could say, and there's really very few limits. You can be very creative depending on the beneficiary, and you can custom tailor the distribution to each beneficiary. So for example, my son Joe is going to get his inheritance, but he's going to get it at 10% a year for 10 years. Or, my daughter Susan is going to get her inheritance, but she's 25 right now, and I don't want her getting a dime until she's 30. And so she can get it when I pass away. If she's 30 or older, she can get it. If not, she's got to wait, right? Some people do staggered distributions, 1/3 after my death, 1/3 5 years later, 1/3 5 years after that. People can make distributions contingent on things, contingent on getting a GED, contingent on getting a college diploma, contingent on keeping a job for an entire year, all sorts of different things that we've seen people do. But that's what a trust can do. A trust can also do some other things here. Divorce protection, creditor protection. These are things that can help avoid creditors at times after after somebody passes. It can also help us avoid, with the divorce protection, somebody inheriting money and then it being subject to division by a divorce court if that beneficiary ends up in a divorce court. Okay. And again, like I said earlier, when you're choosing shoes, you need to consider the whole wardrobe. And when you're designing an estate plan, you need to consider all the assets, all the different ways there are out there to manage things. And so we got to look at this from all angles. Again, like I said earlier, financial maturity doesn't necessarily know an age range, right? I had somebody in here earlier this week who has a son in his 40s, and his mom was telling me that he just can't handle receiving an inheritance all at once. He would be far too subject to spending that much too quickly and frivolously, even though he's in his 40s. So for that lady, for that client, we devised a good strategy when he receives an inheritance, he can receive it gradually and hopefully manage it better than if he received it all at once. No remarriage protection. So a lot of us, our goal, I hear this all the time, we want for our money to stay in our bloodlines. And so we don't, if we pass away, like I said earlier, and our kids receive money, we don't want that money ending up with their parents, or excuse me, with the in-law in the event of a divorce, right? We want that to stay with our kid. Through a trust, we can put in terms that assure that. Something very similar is remarriage protection. And oftentimes I'll have a couple and they'll come in and they'll say, look, this is very simple. We're 64 years old. And we've been married for 20 years. We have 2 kids together. They're doing great. There's nothing, funny here, or excuse me, we've been married 40 years. We've been married 40 years, 2 kids doing great. There's nothing, crazy going on in our families. So this is very simple. And the husband will say, when I die, because he assumes he'll die first, my wife gets everything. When she dies, everything is for the kids. Very simple. But I have to interject with the possibility, what if one of you predeceases early, right? What if one of you are not? What if one of you dies early, or what if one of you dies at 82, but your spouse does what? Gets remarried, because that does happen. And everybody sits here and says, oh, I would never do that. That wouldn't be me, and that wouldn't be us. We won't be doing that. But people that think they won't do it end up doing it, okay? We see it all the time in our office. And so with remarriage protection, what can happen is a new spouse can worm their way into the estate plan, and all that money that was supposed to go to the kids when the second spouse dies, now half of it, maybe more, is going to be going to the new spouse, right? And so there are things that we can put in a trust. Remarriage protection, divorce protection, we have to handle that through a trust, but there's terms that we can put in the trust to really, really prevent that, to cut down greatly on the possibility of that, and to really ensure that the next generation, once both spouses are gone, can receive the inheritance that they were supposed to after the first spouse dies, okay? And those terms need to be in a living revocable trust. They have generation skipping penalties if they're not followed. So the penalty for not following those rules, not adding in new spouses, et cetera, in your estate plan can be that you forfeit all of your assets to your kids right away. So very strong language in there to help with that. And let me tell you, I'll tell you who needs to be worried about this. It's you ladies who are married, okay? Normally, and I would say almost 100% of the time, literally, at least when people come into my office, the adult kids, and I'm hearing complaints about this problem, it is always the mom passed first. Maybe it was unexpected. The dad had a quick remarriage. Usually it's a man who was married to one woman for decades, doesn't really know any different, doesn't want to know any different. So he gets into a pretty quick remarriage. The kids are very leery of the new spouse. They're not happy. That's not their mom. Our mom just died a year ago. What's our dad thinking? What's he doing? He has money. She has nothing. She's manipulating him. She's taking advantage of him. And then they confront the dad. He gets angry and says, well, I'll just cut you guys out of the estate plan if you don't leave me and her alone, right? Then they end up in my office. So the solution to that is to set up a trust while everybody's doing well, alive and well, and to have remarriage protection in that trust so that when that first spouse dies, we can avoid that bad situation that happens to quite a few families. Dump and dissipate. So this is no retirement plan protection. There are a lot of, and I'm not talking about protecting your retirement accounts while you're alive. That's between you and your financial planner. I'm talking about protection of your retirement accounts once you're gone. Right now in the US, the next generation, when they receive retirement assets, 401ks, traditional IRAs, they have to be withdrawn within 10 years. And the reason that in 2019, the Congress said they had to be withdrawn within 10 years is because the government, the IRS, wants their money quicker. They want it sooner rather than later. So you have to withdraw those funds within 10 years. What will the immature, undisciplined financial person do when they receive that $500,000 401k? They will go withdraw every dime the second they can get their hands on it. They don't care what tax bracket they're in. They don't care that they're going to get taxed at 48% instead of 25%. And they're going to go spend it all very quickly. Okay. With a trust, we can control that issue. We can say to the trustee, you are going to give them 10% a year for 10 years. This person doesn't have the option of withdrawing at once or taking a massive withdrawal all at once. They're just going to be, it's going to be given to them every 10 years. They're going to be in a lower tax bracket. Hopefully they won't squander it all real quickly. And so we can set up those kinds of measures within a trust to help with that kind of waste that can come sometimes with undisciplined beneficiaries. Also, remember your shoes must be updated periodically, right? Laws change, people's circumstances change in life. I would say circumstances in your life and your assets changing, or that happens quicker usually than the laws changing, but the laws do change. And like I said, your life circumstances, family dynamics, your asset portfolio, that can change dramatically for some people, even in just 2 or 3 years. It can be a dramatic change and those kind of factors. Another problem that we see, a lot of people do not have nursing home protection. And so what I mean by that is that nursing home cost has gotten pretty high, particularly in a major metro area like DFW. It's going up all the time, just like everything else. The price of everything else is going up. This is going to continue to go up. 50% of Americans who reach the age of 65 will end up in a nursing home. The average cost right now in DFW is going to, or Texas, is going to be close to $80,000 a year to stay in a nursing home. So I sit down with a lot of people and I ask them, well, if one of you has to go into a nursing home next month, how's that? What's your game plan to pay for that? And a lot of times I get a blank look, right? So a lot of people have not planned for this, but what we want to do, we want to pause. We want to think about, okay, if this does happen to us, if I have to go in or my spouse has to go in, how are we going to pay for this? We want to look at that. Okay. Different ways, 5 different ways that we can pay for a nursing home, potentially. Way number 1 is to use your own money. If you have not done anything else, you're going to have to use your own money. You're not going to have an option. Some people actually will use their own money because they have a high enough net worth that they consider themselves to be self-insured. The vast majority of the population of the state of Texas is not in that boat, but there are some people that are fortunate enough that they just say, you know what, we've got enough money, no big deal. But again, most of us aren't in that boat. So then we look at the next option, buying long-term care insurance. So I encourage the vast majority of my clients to look at the possibility of this, buying long-term care insurance. It's not for everybody, that's for sure. Some people, like my wife, they may have had a medical issue in the past that might prevent them from getting coverage. It may not make sense financially. Somebody may be of an age where you're denied, or it's just financially ridiculous to think about. But it's something that I want most people to look into and see, because if you can qualify for it and you can afford it, it's something that can be very, very helpful. And the good policies, they'll offer benefits for home health, assisted living, skilled nursing, and memory care. Okay, so I encourage you all to look into that. Next, we see Medicare benefits. Medicare is not going to pay for a prolonged nursing home stay. Medicare is going to pay for a short 20 to 30 day rehab type stay, not a prolonged nursing home stay. And as soon as you're not eligible, that they let the nursing home know, and they start harassing you for the money. Next on the list here, become eligible for Medicaid benefits. This is something that will pay for your nursing home stay, is Medicaid. However, you have to be at a financial threshold that most people are not happy with. And most people would say, if I get to that point, I'm pretty much poor, and is pretty much considered to be a poverty type threshold if you qualify for Medicaid. There are things we can do, though, through advanced estate planning techniques, where we can help families set up ahead of time through irrevocable Medicaid protection trust, so that those assets, if the person has to go into care, And if it's 5 years after the assets have been put into an irrevocable Medicaid protection trust, so there's a 5-year look back, but 5 years afterwards, the government in the state of Texas has to say, you don't own those assets anymore. They don't belong to you. They belong to the trust. And then, so we've had folks qualify for Medicaid that were way over the threshold simply because they did the advanced planning, the pre-planning, and got that taken care of 5 years in advance. Okay. Veterans aid in attendance, similar to Medicaid, except there's a 3-year look back instead of a 5-year. And it's not, you need to know this too, it's not for all veterans, it's for qualifying veterans. The VA has a list of criteria. And what I recommend to you guys, to all of you, whether you're looking into VA or you're not a veteran, your spouse was not a veteran, so you know you won't qualify for that. This is something, guys, that we want to figure out now. We don't want to wait until that uh-oh moment when the husband has had the stroke and he's in the hospital. He has mental and physical impairment, and the hospital is telling you in 3 days we're releasing him and he has to go to long-term care. You're already in an emotional whirlwind. You don't want to have to go figure all of this out in 3 days in an emotional whirlwind, much less get in to see an attorney in 3 days, much less get with the VA in 3 days, right? So do all of this now. If you're a veteran, check into this now, see if you qualify now. If your spouse is or was a veteran, you may qualify too. And keep in mind with the VA, there's a 3-year look back though. If you can qualify for VA aid and attendance by virtue of your military service, but be disqualified just like with Medicaid because you have too many assets or too much income. But there's things that we can do to remedy that, but that has a 3-year look back as opposed to the 5-year for Medicaid. Okay, another issue that we see is no legacy protection. So whenever we think of estate planning, I think we just kind of think of money, right? We think of passing down our house, our 401k, and it almost kind of seems like we're just a net worth. Like let's just tattoo our net worth on our forehead, and that's who we are when we die. We're our net worth, and of course we all know that's not true. Even though estate planning is heavily focused on passing down assets and money and so forth. At our firm, all of our clients have a binder when they're done with the process. And in the back of the binder, there's a legacy protection workbook for each spouse. And it asks a whole bunch of questions. And all you have to do is go through and answer these questions. And when you're finished, you've left a lot of biographical information about your life, information about your family tree and family history, and information about just things that you felt, were important to you. These could be religious viewpoints, moral viewpoints, philosophical viewpoints, life lessons learned, things like that. So we want to leave behind our family history, our personal history, and maybe some guiding principles to live your life by, so that we hope our future generations will maybe pay attention to that and do better than we did, and maybe not make some of the mistakes that we did. So all of our clients get an opportunity to do that, and we think it's a very good thing. Do it yourself and bare bones wills and trusts. So just to get up on my soapbox here for a minute, I actually talked to somebody about this. Gosh, it was either earlier today or yesterday. Time flies, but I had a conversation. It was yesterday actually with a family, a couple, and they said, "Well, just tell us, why should we not get on LegalZoom? Why should we work with you or work with an attorney instead of just getting on LegalZoom and maybe saving a few bucks?" And so the answer to that, number one, is that in my experience, I have seen a lot of do-it-yourself internet type documents come through my office. Okay. And the vast majority of the time, something is wrong with them. They're either flawed from the get-go, just the documents are just flawed from the standpoint of Texas law, or they have not been executed with the proper formalities of law in the state of Texas. Okay. They forgot to put the date. They forgot to get a notary. They forgot that the witnesses need to be neutral parties, not the beneficiaries. And I've seen a lot of disasters. I have some disaster files for probate right now. And then I've seen people that came in before somebody died or before somebody became incapacitated, and we were able to fix the disaster before it happened. So I highly recommend that you guys work with a legal professional, that you spend a little bit of time and a little bit of money making sure things are done properly. More to the point, I recommend that you work with a legal professional who focuses their practice on estate planning. Okay, somebody that's their day in, day out focus. But at a minimum, I really recommend working with an attorney. And I'll give you a quick comparison to move on. But if my medical plan for my life, my physical health plan is anytime I don't feel good, I'm going to get on WebMD, I'm going to diagnose myself. Then I'm going to go to Walgreens and I'm going to pick out some medicines that I think would be, I saw on the internet, or, buy this over the counter and that over the counter. If that's all I'm going to do for my health, it may work for a while. I may go for a while without any known medical problems, but the chances that at some point down the road of life, that's going to absolutely blow up in my face is really high, right? We need doctors pulling our blood, analyzing our blood, telling us that you need to do this, you need to lose weight, you need to eat less salt, you need to take these pills, cholesterol is high. The people who don't do that, they end up with worse problems than the people who do. They usually die much more prematurely, right? So it's the same thing with legal issues. The exact same concept. If you don't have a professional do this the right way, the chances that it's going to blow up either in your face or in your family's face when you die, when you pass away, is really high. Okay, so recommend that everybody use an attorney to get your legal documents done. Okay, and remember, a good fit is essential with a pair of shoes and with an estate plan. Poor fitting pair of shoes, even if it's attractive, can leave you and your feet miserable if they're way too small, right? Or if they're too big and you're walking around in them getting blisters. That happened to me once when I was younger. And same thing with an estate plan. We don't want to get all hung up on I want this and I want that. It's more, what are your assets? What are your family dynamics? What are your goals? And then let's fit the plan, let's fit the documents within that framework. Let's talk quickly about what is a living trust and how does it work. And we're getting close to the end here. And so that you guys know, I do see in the chat section, I don't know what they are yet, but I see some people have put probably some questions in. I will be answering questions at the end. So feel free now, if you want to start asking some questions, you can go ahead and put those in the chat section because we're pretty close to the end here. So what is a living trust and how does it work? Well, a living trust is a document. It's white pieces of paper with black ink that says a lot of fancy legal words and legal terms. But what it can achieve is really pretty magical and amazing. It can empower us to avoid probate court. It can empower us to potentially avoid the federal estate tax. It can empower us to treat our beneficiaries completely differently in how they receive their distributions. It can give us divorce protection. It can give us remarriage protection. So it can do a lot of things that no other document can do. So let's look at it this way. The trust, it's the Porsche or the Ferrari of estate planning. It's the most advanced, fancy document that we have, okay? A last will and testament, I call it the Model T Ford of estate planning. And again, the trust is the Porsche. But the Model T Ford is okay for some people. Some people don't need the Porsche. It just depends. So again, the magic is in how you hold title to your assets. So if my trust has title to my assets are held in the trust, I get all those advantages. Don't go to court, avoid the estate tax, treat each beneficiary differently, divorce protection, remarriage protection. Now, with a trust, if you set up a trust, and if you're married, you and your spouse, you guys are the trustors, meaning you're the creators of the trust. You're the trustees, meaning you manage the trust while you're alive. And then you're the beneficiaries, meaning when you pass, before you pass, all of the assets are for your benefit. Nobody else gets those, gets to use them, gets to withdraw, just you until you pass away. Then we get a new trustee, then we get new beneficiaries. A lot of people have a feeling or an idea that if they set up a trust, they connect their assets to the trust, everything is just kind of frozen and I'll never be able to get things out or put things in or refinance. And is my stuff just kind of trapped and frozen in this trust? And the answer is no, particularly with a revocable trust, which is what we're talking about today. Super fluid, super flexible. I see no downside to a revocable trust. I see a lot of upside. So revocable trusts are very, very fluid, very flexible. easy to manage, easy to navigate. You do, though, if you have a trust, you want to make sure that it's fully funded. That means that all of your assets are connected into the trust. So we say that an unfunded trust is like an empty shoebox. Okay, back to the shoe analogy. If I have a shoebox and I'm so excited because I've got these great shoes in there in this shoebox, and I open up the shoebox and the shoes aren't there, the shoebox is worthless to me, right? I don't want a nice shoebox. I want a nice pair of shoes. The box just happens to come with it, right? So it's the same concept. If your assets, if you have this beautiful, great trust that's the most well-drafted legal document in the history of mankind, but you have not connected your assets to it, you have not funded your assets into it, it is totally worthless. Might as well just put it in the fireplace this winter, right? Burn it. So you need your assets to be connected to your trust. We take great pains to help our clients with that, and it's very important to us here at our firm. So I want you guys to think about something here for a minute. Now, first, let me tell you, I offer a complimentary consultation to any individual or family for the very first consultation for up to an hour. So you can have up to an hour of my time complimentary. And all I ask is that you, if you're married, if you can include your spouse, especially if y'all are, joint decision makers on this kind of a thing. And just that by the time we're done, you've got a definite yes or a definite no. But I do, within that hour, I'll ask my clients, the prospective client, bring in your current estate planning documents, whether they're old, new, from Texas, from out of state. Bring them in, I'll look at them. We can talk about what you have in place now. We can talk about your goals and what we can do to get your estate in better shape with the estate planning. And then it's just simply up to you to decide if you want to take advantage of that. But I encourage all of you guys to take advantage of that consultation. Okay, there's no harm in it whatsoever. And I want you to kind of imagine this right now. And I'm sorry that I always have to be within the context of my job, my career. I'm kind of I feel like I'm always asking people to put themselves in the worst positions possible mentally. But imagine if this weekend you or your spouse has a big medical episode. Could be a car wreck, could be a stroke, could be a heart attack. And one of you is either gone, just deceased, maybe not deceased, but mentally incapacitated, and maybe needing to go into nursing care. Okay. After everything that we've just talked about, if something like that were to happen to your family this weekend, next week, what would your spouse or your children be looking at? Would they be looking at a big mess? Would they be looking at just cutting checks mindlessly to the nursing home, $6,000 a month, $6,000 a month? Would they be looking at navigating the court system without a will? Would they be looking at going through the court system when they could have been set up to completely avoid it, right? And all the time and expense and stress that comes with that. So again, if the answer is that, you know what, if that happened this weekend in our house, I think there'd be some problems the next week. I think we'd have some difficult things to work through. I highly recommend not procrastinating. Give us a call, and you would meet with me personally for up to an hour. And if we do business together, that's great. If we don't, that's absolutely okay too. But thank you guys so much for listening. Again, the shoe analogy was a new twist. I hope it made sense and worked out for you guys. And then I think, Zoe, I'll turn it over to you now. But thank you guys so much.
Fantastic. I like the shoe analogy. It worked really well.
Good. I'm glad.
It did. It definitely did. All right, guys, did anybody have any questions? And I apologize. The comments were because I said I wanted a pair of those shoes in my size.
Okay.
Let's see. Brenda Moreland did say it's great information, which it definitely is great information. I agree with what Brandon said. Is it's not always the most comfortable of topics to talk about, but it's an important topic to talk about because we want we want your life to be easier, whether it be for yourself because a loved one passed away, or for your children, whoever it is that's dealing with your estate. it really does make a big difference to have everything in line. I mean, we got to have these conversations. They aren't fun, but they're necessary. So
Absolutely.
I don't see any questions in the chat. Guys, make sure, like Brandon said, I mean, it's really gracious that he offers that free consultation. You'll be able to discuss with him more personal items related strictly to your own circumstances, and he can lead you in the right direction. So that being said, Brandon, thank you for joining us today.
Yeah.
Thank you to the entire McGee Law Firm and the team for doing such a great job today. And everyone have a fantastic weekend, and we'll see you next week.
Yeah.
Bye,
Thank you guys so much. Take care.
Thank
Bye-bye.
you.